Yay, last session of the day.
I see you all are so excited about this.
Everybody ready to be ethical? Okay. So the title of this one is The Quagmire, Ethics in the Gray Area, and we will be hearing from Miss Whitney Untiedt. She's a trial attorney at Frieden Brown, PA, a civil litigation firm based in Miami, Florida. Whitney maintains an active practice leading the firm's national whistleblower and, I can't even say that, qui tam practice, while also representing victims of medical malpractice and complex injury. Before that, and I'm going to go off script because you can read this. Before that, Whitney was the pro bono attorney at another large firm, and she is on the used to be on the National Juvenile Defender Advisory Committee. Now she is not, because she has kind of stepped down when she went into the civil firm. But she's also a member of SJDC, which is the Southern Juvenile Defender Center, which you can be part of because you're in the South and in this jurisdiction. So Whitney is also a certified JTIP trainer, which is a juvenile training immersion program, and she is a wonderful litigator. She is compassionate and she is caring about our kids. So I think that she's going to teach you some ethical things here. So would you please help me welcome Whitney Untiedt?
Thank you, Brenda. Okay, so I'm from Florida, which is not necessarily known for our ethics, which has meant that I've spent a lot of time thinking about ethics and professionalism in the law, and in particular, ethics and professionalism in juvenile court. So what I want to talk with you guys about today, number one, starting with the rules. After we go through kind of where our guidelines for ethics begin and end, we'll talk about our loyalty to our client and how ethics really helps to inform the work that we do in all of the areas that Tim and Brenda and the other presenters have spoken with us about over the course of this training. We're going to talk about ethics and case investigation, looking at case investigation and trial preparation through the lens of ethics. And then at the very end, we've got some scenarios to discuss as a group. What can you do? What can you not do, and what should you do? As all of you are, I'm a trial lawyer. I can talk for hours upon hours on end, but I find that these things are generally more exciting and interesting to all of us if it's a conversation rather than a presentation. So please feel free to interrupt me. Please feel free to challenge me. This presentation is called Ethics in the Gray Area because we're going to be talking about decision making for the lawyers, not when it's an easy decision, when there's definitely one right answer and one wrong answer, but when there are multiple possibilities in front of us and how we make the right choice for our client and for our case on an individual basis. So starting with where we look, the rules, what we're looking at, what helps to define our ethical approach to child representation. And I view it as sort of like a Russian nesting doll idea. We've got in the very middle, the smallest one, are the rules of professional conduct, right? If we break a rule of professional conduct, then our license is on the line. This is our bare minimum, our rules that we cannot break, the things that we must do. Overlaying that, our next layer is our ethical approach, right? I can technically follow the rules while not necessarily taking an ethical approach. I can do what I need to do, the bare minimum, to keep my law license without necessarily being ethical. And then encompassing all of that is professionalism generally. And I can guarantee you that each one of us in this room has practiced law with and against people who follow the rules, people who are ethical, but who are unprofessional, right? Because there's a difference between following the rules and a difference between being ethical and being professional. Professionalism is the aspirational standard that I'm sure all of us in this room aspire to, and hopefully all of us in this room meet every single time we do something on a case. If you're being professional and if you're being ethical, you're going to be following the rules, that nucleus here in the middle. So where do we go for guidance? What helps inform when we've got an ethical conundrum, when we're caught in the quagmire? Where do we look to figure out what we can do, what we must do, and what we should do? Okay, so Mississippi Rules of Professional Conduct. When has anybody gone to, actually physically looked at online or in your book, the Rules of Professional Conduct within the last week? I have, because I've prepared for this conversation. Within the last month? Yep. Within the last 6 months? Within the last year? And when you're reading the rules of professional conduct, are you looking at the comments too? There are some gold mines in those comments. In reading over, and we'll talk about some of them earlier, you can really see where the folks in Mississippi charged with determining what our rules of professional conduct are, where they get really persnickety about what lawyers are doing and not doing in the courtroom. And I would suggest that when a conundrum presents itself, the Mississippi Rules of Professional Conduct are probably the first place you're going to go, but where else do you look? Statute, case law, Mississippi Youth Court rules. There are court rules that help to inform our ethical approach to our practice. Has anyone in this room besides me and Tim ever reviewed the National Juvenile Defender Center standards? So they're free, they're online. All you have to do is go to www.njdc.info and click through just a couple screens and you'll find NJDC's standards for juvenile defense. Those standards are the professionalism. They're not just the rules, they're not just ethics, but they embody the entire panoply of approaching juvenile defense. And they will suggest that as a youth court defender, you should be going above and beyond the bare minimum of ethics because of the vulnerability of the person that you've been charged to represent. There's also the Campaign for Fair Sentencing of Youth has provided, and it is as well online, free and available to anyone at www.fairsentencingofyouth.org. Trial guidelines specifically for representing kids in transfer hearings and kids in adult court, but those same principles and values are going to be here in youth court as well. So we've got covered here places to go, the rules that you cannot break or you will lose your law license, the ethics that surround those rules, which you'll find in the commentary to the rules, and then the wide-ranging professionalism and aspirational standards. We got to know where to look, we got to know where to go, because we got to be able to figure out what to do when we're in this gray area and we have to make decisions individually because we have a special loyalty to our client. Who's a kid, right? Anyone have teenagers at home? Some of you at least used to have teenagers at home. So you know what it's like to be bossed around in your daily life by someone who has very little life experience. And then you come to work and you're in youth court, and again, you are being bossed around in life by your client who has very little time on this world, right? So how do we navigate this conundrum? What does it mean to be a child's lawyer, and is it different from representing an adult? So it feels in some way that there is perhaps even more on the line when we are representing youth in youth court than there is when we are representing adults. Adults have been there, done that. Kids, youth, juveniles are one day going to be there, one day going to do that. And part of this heavy burden that we carry as their lawyers is really being part of defining where there is and what that is. Any other reasons or ways that you have seen through your practice that representing juveniles in youth court is different than representing adults? So there's the issue of general experience, potentially an issue of client competence, client knowledge and understanding, and kids live in this world of rumor and innuendo, right? Peer pressure is an actual thing. And why should they trust you, this random person that's been inserted into their life, when their aunt or their uncle or their homegirl down the street is telling them something completely different? So the idea that we may have a greater responsibility ethically and professionally to spend time with our client, to develop a relationship with our juvenile client, to explain step by step by step what's happening to our juvenile client. How else? Is there a different consideration of the rules? There's more people inserting themselves or attempting to insert themselves into our relationship with our client. It's their parents, it's their aunt, it's a well-meaning member of the community that has a good relationship with the child. How do we deal with that? I don't know. This is the gray area. Do you let the parent come in to your meeting with the child? It's up to the child. Sometimes I saw a head shake over here that was a nod. Are there ever any exceptions to wanting to see the child with the parent the first time you meet? Yeah, teenagers are great communicators, aren't they? Tell me what happened. Who else was there? It's that says so many things, none of which are helpful when you are a lawyer trying to investigate a case, trying to figure out what happened, trying to find witnesses. Kids are also, as part of their biological being and their brain development, not particularly good recollectors. They're not very good at timelines. They're not very good at details. They're not very good at telling a coherent and comprehensive story. Adults are a lot better at that, and if their parents were there and also not the victim, their parents may be better at helping you to understand what actually happened. Right? So thinking about conflicts, potentially, thinking about a witness identification, because you ask your client who Peanut is, and your client's answer is something along the lines of, well, I don't know him like that. Okay, you were out with him at 3 o'clock in the morning, fine, right? So the question of all of these other people who are involved. And so when we are the child's lawyer, our duty is to the child, our loyalty is to, and our job is to represent. It's amazing how the answer was all the same, right? So, but there is also the push and pull, because like Lynn was saying, part of the heavy burden that we carry is that in youth court, we may be able to be part of setting this kid up for going the right place as he or she moves on in their lives, right? We may be able to be part of, as Lynn put it, saving this kid from his situation or or from herself. And there's more of that push and pull in what we do and what our responsibilities are than there is in adult court. And that push and pull comes down to how we advocate on behalf of the kid, right? Who are the other players in youth court, in the youth court system? So we've got a prosecutor, and what interests does the prosecutor represent? The interests of the state, of the people of Mississippi. Who else is in the room? We've got the clerks. Clerks are there to do the record keeping, right? They're not really going to be advocating on behalf of anybody. Who else? Pardon? Youth Court Counsel. And what interests do they represent? Yeah, they represent the department, they represent rehabilitation, they represent, on some level, their belief in whatever the best interests in the child are. Who else is there? Well, we've got the judge or the referee, right? The ultimate decision maker, who ultimately is going to be thinking about things like community safety, rehabilitation, best interest of the kid, saving the child. Who are the other players in the system? Maybe a guardian ad litem. And who ultimately does the guardian ad litem answer to? The judge, right? The guardian is there to provide an investigative report to the judge on what the best interest of the child are, not guilt or innocence, but best interest of the child, rehabilitative interest of the child, what the judge should do to help save the child from him or herself. We've got the police officers. They're looking out for the community and often are not standing on our side of the courtroom. We've got probation officers. We've got community providers, our therapists, our drug counselors, the people who may or may not be working with our kids. We've got educators. We've got other friends and family in the community. We've got parents. We've got all of these people looking out for all of these things. And then we've got us. Ultimately, ethically, so that we are here in the middle, not right here with the rules, what do we represent? We represent the child. What interests do we represent? We represent the criminal interests, right?
They often get shoved into also trying to represent their best people.
And who tries to do that?
The judge tries to make us be the criminal defense attorney and the GAL. They don't name us the GAL, but they try to make us be the GAL.
Yeah, and by trying to make you the GAL, they are trying to get you to rat out your client in some ways, right? You know, they'll say that they won't ask for what did your client tell you, because they know at least that that's protected by attorney-client privilege. But they might ask you, what do you think should happen? What do you think your kid needs? You know, don't get up here and tell me this kid needs to be released from detention. You and I both know that this kid's running around town all crazy, breaking curfew. Tell me what you really think, counselor. Is that our job? What do we do when the judge is asking us for best interest information that is clearly not in our client's expressed interest? Okay, so we're going to talk about mandatory reporting in a little bit. I want to suggest to you that if we're representing the kid's expressed interest, and the kids' expressed interest are in direct contradiction of what we believe to be in their best interest, that it still may not be our role as the child's lawyer to be the one to ask for a guardian ad litem that we know upon investigation is going to recommend something to the court other than what the kid wants. Well, we have a duty of candor to the court, right? We can't lie to the judge, if the judge looks at us and says, counselor, is this the type of case where I'm supposed to appoint a guardian ad litem? And if it statutorily falls in that category, I can't look at the judge and say, no, Your Honor, you don't have to. But do I have a proactive duty as the expressed interest lawyer for the child to proactively tell the judge to do it? So tactically, maybe it's to my advantage, but what if the kid says, I don't care? I don't care. I know, but I want to stay home. I know that bad things are happening, but I want to stay home. I don't want a guardian ad litem because they're going to make me do a drug test and I'm going to test dirty. I don't want a guardian ad litem because I know that they're going to say I need to go to counseling, and I don't want to go to counseling because you can see them doing it. And an adult, at least, when you know that they're making bad decisions, they at least have some life experience, and they probably know where their bad decisions are going to leave them. But this kid, and we're supposed to save them, and we don't want them to end up in the adult system, and that we don't want them to be setting themselves up for breaking probation and ending up with a transfer eligible offense, or ending up in some horrible lockdown facility, right? This is why our job is so very hard. This maybe is me on my way to make bad decisions, but like for me, bad decisions at this point in my life is like wearing heels that I know are gonna hurt my back by the end of the day. I don't get, I think, quite as much joy as my clients when they are knowingly and voluntarily walking down that rosy path to make their bad decisions.
Is that your dog?
I wish it was. Seems like a very happy dog on its way to go do something scandalous and illegal. But so instead of right now talking about our client's decision-making process, I want to talk about decision-making in the courtroom and where ultimate responsibility for decisions in a case lies. Who decides whether to go to trial or plea? The client. That's an easy one, right? Who decides whether or not the client testifies at trial? The client. Another easy one. Who decides what witnesses we'll call at trial? Well, the kid can testify, but who's going to make a decision about whether to call Peanut, who is perhaps an unindicted co-conspirator in this particular case, to testify that your kid was not there at the Walmart when the toothbrush got stolen? Whose decision is that? We've got one hardcore for the lawyer. Well, generally, probably we're not going to have a kid tell us we can't call somebody, right? Because
They don't even know what witnesses they're thinking about.
we might have a circumstance where a kid says, I want you to call my friend. He's going to testify for me. He's going to say that I wasn't there, or he's going to say I didn't start the fight. So this is where our ethical rules and our Mississippi rules of professional responsibility come into play. Number one, Rule 1.4, client communication, and Rule number 2, 2.1, advisor, right? Ultimately, our client is the captain of this boat. Our client tells us where they want the boat to go, whether they want the boat to go to trial or whether we want to take a detour and take a plea, whether they want to testify or whether they want to exercise their right to remain silent. They are the captain. We are the pilot. Once we have our direction, once we know where the client wants to go and what the client wants to do, it is our job to try to pilot the ship to the place where the client ultimately wants to go, even if we're like 99.9% sure that there's an iceberg in the way. And we're never going to get to that not guilty, that not delinquent finding, right? But it is our job along the way, just like any pilot who is plotting points on the map, to keep our client informed, to talk with our client, even the 12-year-old, the 13-year-old, the 15-year-old, the really snotty 17-year-old, to talk with them to make sure that they understand what's going to happen. And even if ultimately they disagree with our decision making, that we have explained to them why we have to make a certain decision. I can't call Peanut because I know he's gonna lie. And I know he's gonna lie because he told me he was going to, right? I can't do it. I'd love to, but I can't. What else do we have ultimate decision-making power over for? Who decides motion filing? We do, right? If there's going to be a motion to dismiss or a motion to review the detention status, we're the ones that ultimately file that. But of course, we're still wanting to communicate with and advise our kid, our client, on why we're doing it, what we're doing, and what the whole point is. Here, I think, is the hard part. I mean, we're all trial lawyers. We're really good at persuasion. Persuasion is our job. And our child clients, and probably many of our adult clients too, we have persuasive power over them. With my 15-year-old client, I can talk you into a plea if I want to. And then just for fun, I can talk you right back out of it. And then I can talk you right back into it if I want to, all within the confines of a 15-minute conversation, because I'm a lawyer, because you're lawyers, because persuasion is our job, and because persuasion is how we ultimately advocate for our clients. So we talked about communication, and we talked about advising our clients, and we talked about the different decision-making powers that we have versus our clients throughout the trial process. How am I supposed to advise my client without ultimately influencing their decision-making? Should I be attempting not to influence their decision-making? What's my job when I can see my client going down that path of no return on a particular case? I know I'm supposed to advise them because the rules say. I know I have to keep her informed and communicate and advocate zealously on her behalf because the rules say. But here I think is the quagmire. Here's where I don't see necessarily one right or one wrong answer. What do I do? How do I do it? How do I approach my role as the zealous, expressed interests advocate for my client when I disagree with what my 15-year-old client is directing me to do? What approaches have you guys taken? So taking the time to lay out all of the possible choices and all of the possible consequences, good and bad, of those choices. So, and like you said, we have that obligation because the rules tell us that we have an obligation to communicate to our client and to give our legal advice to our client, right? It's the juvenile defender's morning prayer. Dear God, please don't make me lie in court today. Right? It's tough because we're advising our client, we're giving them all of the information, our best legal advice. We're telling them, listen, if you don't make me do this, if you don't put that video in front of the judge where that person on the video looks an awful lot like you, then maybe it's going to be a better outcome for you. Maybe the judge will decide to do probation instead of a facility, right? And then the kid still tells you no, and you put on your suit jacket and you walk into court and you just do your best, right? I mean, advising and persuading is, I think, the biggest ethical quagmire in the pretrial period. How far can we go without overstepping? And how do we make sure that we go far enough in advising our clients so that they truly do understand the consequences? So then it comes down to communication. And again, we're here with our rules of professional conduct, 1.4, client communication, and 2.1, advice. And we've talked about most of this, right? Complying with requests for information, explaining with enough detail that it's not just enough to say the judge is going to find you guilty, but explaining with enough detail so that the client can make an informed decision, even if their decision goes against the information or our thoughts on what the client should do. We do have that duty to render candid advice, and we do have the duty here to make sure that the client understands all considerations relevant to their situation, which often go way beyond the confines of the legal case and the factors in front of us. So if we have a duty, and if the National Juvenile Defender standards tell us that our duty and our responsibility is to zealously advocate and represent our client, what considerations besides guilt, innocence, police arrest form, witnesses, case, are we supposed to be talking with our client about during this decision-making process? I mean, all considerations relevant to the client and their situation, right? So maybe then we have a responsibility to be talking with our client about, if you end up on probation, here are the rules you're going to have to follow. Do you think you can follow those rules? You've been on runaway status for the past 3 weeks. Do you really think you can live at home while you're on probation? You're gonna have to go to school. You're gonna have to drop drug screens. Things to talk with our clients about outside of just, did you do it? Did you not do it? What witnesses were there? If you didn't do it, who did? This other difficulty, client confidentiality. Because the rule says, right? Rule 1.6, a lawyer shall not reveal information relating to the representation of the client. It seems cut and dry. And then there's all those exceptions, which make our job, our rules, our ethics, our professionalism that much more difficult. Because after that clause, you shall not break client confidentiality. There is then the magic word, unless, right? And then there's all these reasons that a lawyer may reveal information. And then the question becomes, our ethical consideration becomes whether or not we are going to reveal confidential information when it's permissive to do so. Because the rule says a lawyer may reveal confidential information if, number one, the client gives informed consent. Number two, the disclosure is impliedly authorized by your client. Like, what the heck does that even mean? And number three, if the lawyer reasonably believes that it's necessary to prevent death or serious bodily injury. How do we navigate that? The law doesn't say you have to. We'll talk about mandatory reporting in a minute. But in this particular rule, you may share confidential information if you have a reasonable belief that it's necessary. How do you determine whether you have a reasonable belief that it's necessary to share confidential information? Are you going, here's another question, are you going to investigate to determine whether you have a reasonable belief? So say, for example, your client is charged with battery on another kid and your client's in detention, the other kid's in school, they would go to school together. Your kid tells you, I want to get out of detention, I want to go back to school. And then at some point the kid says, and I'm going to kick that kid's butt the next time I see him. Do I have an obligation to continue the conversation, to elicit information, to make a determination about whether I have a reasonable belief that the other child is in imminent danger of serious bodily injury if my kid gets out of detention? So thinking about whether the statement that might prompt a probing occurred sort of as an off-the-cuff, offhand remark that you don't actually think your client really intends to do, or whether there's some sort of history that might lead you to believe that your client would follow through and that it would result in more than just another schoolyard fight, because it's serious bodily injury and not just a punch in the nose, right? And also then whether or not you want to continue down a road to develop a reasonable belief that you may need to report a confidential communication with your client, and whether you're going to do that. So one approach certainly is, unless I absolutely have to, I am not going to break client confidentiality. So let's talk about in what circumstances we might absolutely have to. Under the statute, as lawyers, because it's the first thing, all attorneys, and then blah, 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 must report a neglected child or an abused child if you have reasonable cause to suspect that a child is neglected or abused. So then again, although it's a must, although it's a got to, we have this squirrely language in there. Reasonable cause to suspect abuse or neglect. And again, how do we determine whether or not we have reasonable cause to suspect? And do we have an obligation based on a child's statement? So for example, I've been running away because my stepdad beats me. The statute says reasonable cause to suspect. If my client makes that statement to me, does that statement in and of itself, and there is not necessarily a right or wrong answer to this question, does that statement in and of itself require me to mandatorily report? Does that statement in and of itself require me to say, if you tell me anything else, I'm going to have to mandatory report the incident. So I want you to think real carefully about whether you want to open up to me about this. Does the wording in the statute require me to investigate, either talk with my kid more about it or do an outside investigation, talk with teachers, talk with other family members? What does the statute require me to do based on this language? And then the extra guidance tells us we are supposed to use our professional expertise to determine whether or not we've got a reasonable belief. Well, what does that even mean? Or what if my stepdad beats me really meant, I'm really mad at my stepdad because he took away my iPhone and doesn't let me play, what is it? What is that game? Fortnite. Doesn't let me play Fortnite, and I'm mad. That may not be an actual reportable offense, but what is our responsibility to determine what lies behind that statement? I don't know. That's why they're paying me the big bucks to stand up here. All of this is really, really hard, which is why we go back to the statutes, which is why we go back to the rules, and why we ultimately go back to the standards to determine on a case-by-case scenario what we can do, what we must do, and what we should do. Because it really may be a different answer for any individual situation. I want to talk about the ethics of case investigation beyond and past our obligation to our client, our obligation to investigate the case. We've got sort of in the middle the little bit of information about what we know, and then surrounding that is what we don't know, what we need to know about any particular case. Our meta-knowledge. Is anyone familiar with the term meta-knowledge? Right, so meta-knowledge means knowing what you don't know. It's like that third step. There's what we know, knowing what we know, and then there's what we don't know, and then the investigation part, the meta-knowledge part, is figuring out and knowing what we don't know, and then finding our way into knowing what that is. So our rules, again, tell us what we are supposed to do here. Competence, rule 1.1, it's like the very first one. A lawyer shall provide competent representation to a client, which requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. Competence, diligence, zealousness, legal knowledge, thoroughness, and preparation. The comments to the rule tell us that competent handling of a particular matter includes inquiry into and analysis of the factual and legal elements of the problem, and use of methods and procedures that meet the standards of competent practitioners. And then they tell us that major litigation ordinarily requires more elaborate treatment than matters of lesser consequence. Where on that spectrum does representation of a child in youth court fall between matters of lesser competence and major litigation? I would suggest to you that in youth court, even though we're just in front of a referee or a judge that's conducting a bench trial, even though it may just be a misdemeanor, that like we've talked about throughout this entire conference, we are representing a person whose life and future are on the line, and that on that spectrum from matters of lesser consequence to major litigation, representing a child falls on the major litigation side of the zero line, even if it's just a misdemeanor, even if it's just a first offense. And so as the NJDC standards tell us, our role, we must provide competent, diligent, and zealous advocacy to protect the client's procedural and substantive rights. So how do we do it? What's our checklist? What are the things that we are ethically responsible for doing in any investigation of any case? What do? You get the case in. So when you get the case in, you get a police report, maybe, a recitation of the facts at your detention hearing. The case is assigned to you. What do? What are your steps? Do you have an obligation to talk to your client? Yeah, okay, so that's number one, that's an easy one. Right? So competent, zealous, and diligent representation requires us to participate in the formal discovery process and requires us to require the prosecutor to do their job in handing over their file to you. It requires us to interview witnesses, the ones who are on our side and the ones who are against us. It requires us, perhaps, to actually visit the scene of the incident, to actually watch the video where it is alleged that our client is stealing stuff from Walmart. Requires us to look at those background witnesses, the teachers, the community providers, the family members, the people who don't have anything related to the actual incident, but they do have information about our client's situation, how our kid is doing in school, how our kid is doing in the community, and how she's doing at home. To review the physical evidence, perhaps to make a public records request to get information that may be in the police investigatory file or maybe out there somewhere that the prosecutor has not disclosed to us, or perhaps even that the prosecutor doesn't have, to make those credibility determinations and ultimately to draw up our case plan and our case strategy, which we need to do regardless of whether this is a plea and then we're going to be at the mercy for court for sentencing, or whether we're going to a trial and there's going to be factual and legal issues at hand. So if we are going to a trial, our trial prep checklist. What are we doing in preparation for a trial? Making our discovery requests, doing a check-in with our client. How are you doing? What do you want out of this case? But also with those background witnesses, so we can make our mitigating presentation to the judge and advocate for something less than what the prosecutor is asking for, filing pretrial motions, selecting our exhibits, and thinking about our case theory and strategy. And I have up there getting sworn witness statements, because there's ways to do it outside of depositions. You don't even have to have a notary public and have the witness raise their hand, right? You can go to a complaining witness or to an adverse witness or to a witness who's on your side and have them write out a statement on your own and sign it. And you can use that for impeachment later, or at the very least to help you prepare for trial. You don't even have to get a written statement. You can go with an investigator or with someone else from your office and interview that person with two people there, so that you have a second person on hand who can then impeach the witness if they change their story at trial. There's ways outside of depositions to get our sworn witness statements, and preparing for trial competently, diligently, and zealously would suggest that we need to be doing that. And then here's another little ethical quandary I want to consider with you, is our witness preparation. Competent and diligent trial preparation means that we have to be preparing our client and our witness to testify. What does that look like? Is there a difference between preparing your client to testify versus preparing a witness to come testify on your client's behalf? What's the number one difference? The number one difference is confidentiality. You and your client can talk about anything you want to talk about as you are preparing them to testify, and your client cannot be asked, what did your attorney tell you, right? We have to be a little bit more careful when we are preparing a non-client witness to testify, because that conversation is potentially discoverable and potentially can be used against the witness on the witness stand. What about helping to shape a witness's testimony? Where are we on the ethical spectrum here? Can we tell a witness what to say? Can we tell a witness what words to use? I see people saying no, and I'm wondering if anybody wants to challenge that. Because go ahead. I will suggest to you that as long as you are not changing the facts, as long as you are not suggesting that the witness say something that is untrue, that within those shades of gray, you may be completely 100% within your rules, your ethical, and your professional bounds to tell a witness what words to use. Because you want them to be testifying relevantly, and if they have good information that supports your theory of the case, you want them to get that information across to the court, but they have to be comfortable in the way that they're presenting and in the words that they're using, and if they don't feel comfortable saying those words, it could very well be that their credibility is questioned by the court, that they don't ultimately do what you're asking them to do or say what you're asking them to say because they get nervous, not about their testimony or about their story, but about the fact that you have drilled into them the exact words that you're wanting them to use. But I will suggest to you that on this spectrum, in this gray area, it may not just be that you can help to shape a witness's testimony, either your client or someone else, but perhaps that in zealous and diligent representation of your client, you should be preparing your witness to give the best truthful testimony that they can in support of your theory of the case. And now with the 15 minutes or so, 20 minutes or so that we have left, I have a couple ethical quagmire scenarios for us to go over. And what I'd like to do is to sort of clump some of our tables together so that we have 4 tables. So maybe if you guys will come over and join these folks, and if you'll go back and join them, and if you guys will go over and join those guys. Unfortunately, the printers around here only like to print about half of the stuff, so I don't have copies of these scenarios for everyone, so you'll have to share, and I apologize for that. But what I'd like for you to do at your tables is to read over the scenario and to think through all possible options of what you could do in response to the scenario. So not stopping or starting with what you definitely would do in this particular given scenario, but all possible ways to address the situation. So assuming that the judge or referee that hears the delinquency case is also hearing the abuse and neglect case, they know that you're on the delinquency case and that you've worked with this kid for a while, and now they're appointing you guardian ad litem in the abuse and neglect case. What are all possible courses of action that you could do? Can anyone think of any other courses of action that you could take in this particular scenario? So your judge has appointed you, the order has been entered, has appointed you guardian ad litem in the abuse and neglect case. You are current counsel on the delinquency case. Is there anything else you could do besides file a motion to withdraw? So you could try to get the delinquency case dismissed. Any other courses of action? Now remembering, this judge has got a fragile ego. I didn't put that part in. This judge has got a fragile ego, and this judge is the only youth court judge in your jurisdiction and makes determinations about whether or not you're going to get paid, because this judge makes determinations about whether or not you're going to get appointed on any cases in your jurisdiction. Any other courses of action besides filing a motion to withdraw? So we got the ethical issue, right? The ethical issue is the rules and the statute specifically say you cannot be a guardian ad litem if you are also the representative, the lawyer for the child. We also know that we have our client confidentiality and attorney-client privilege that prevent us from being able to share information that as a guardian ad litem we would be obligated to share with the court. So this is not an ethical difficulty for us. We've got to get off the GAL case, but this is also a jurisdiction where the judge has got a lot of power, and we would like to continue representing other children in youth court. Are there options besides filing a motion to withdraw? Is there the kinder, gentler approach to getting off of the GAL case that we might be able to employ? Yeah, well, I mean, I'm probably not going to have an ex parte communication with the judge, but maybe I'm going to take the prosecutor with me, or because the guardian ad litem was appointed in abuse and neglect cases, maybe I'm going to take the lawyer for the department with me to go into chambers, to send an email copying all relevant parties saying, Your Honor, I believe the court made a mistake and I can't be guardian ad litem. I would love to, of course, because I think you're the best judge ever, and I always love appearing in front of you. So, yeah, right? Because it's difficult. In Mississippi youth courts, the judge is kind of like a king, almost, and can determine the fates of his or her subjects at will. So we've got the motion, which we can file. We also have the kinder, gentler approach for considering this potential ethical quandary. I am glad that we are all in agreement that we are not going to accept that GAL appointment. What about this table back here? Under the rules, bare minimum rules, do you have to have that conversation with him? Are you required by law to have that conversation with him? Do you have to establish reasonable cause? Are you required under the law, given the fact that he has told you he walked to your office today and he's hungry because he hasn't eaten today, are you required under the law to follow up to determine whether you have reasonable cause to believe that you must report this as a neglect case? Because this is really hard, right? I think we can all agree that if a kid shows up to your office having potentially walked miles from wherever he stayed that night, and he's hungry because he hasn't eaten, and it is apparent to you that nobody is taking care of this child that is a human being, we should try to find out what's going on, right? As a lawyer with an ethical responsibility under 1.4 to communicate with our client and 2.1 to advise our client, part of that conversation probably also entails a discussion of what this means I may have to do. And maybe even under that professionalism standards umbrella, working to get our clients' buy-in to make that call, if it's a call that I have to make, right? It's a difficult situation, and one that if we're paying attention when our clients are coming to see us and we're paying attention to what our clients are telling us, probably raises its ugly head more often. Because parents insert themselves into our cases all the time and cause quagmires that should not actually exist. And you know, we probably more often than judges realize that the child is not 100% the problem most of the time, right? But then ultimately, if we go back and we have the conversation with our client and the kid says, I don't want ankle monitor, I'm not doing any of this stuff, I just want to go home, ultimately, we put on our jacket, we walk in the room, we stand up straight, and we say, practicing our chants for Saturday, we say, Your Honor, our client wants to go home, and we make that zealous advocacy and we make that argument zealously, even knowing we're going to lose. So I think my time is pretty much up. We have 4 minutes. Does anybody have any questions or pushback? Are there any issues that you're dealing with that we haven't discussed that you'd like some group input on, so that when you go back to court on Monday, you've got your ethical, your rule-oriented, and your professional approach polished and ready to go? Brenda, Bo, Tim, is there anything that I have missed or that we have a need to discuss more? All right. Well, then I think you guys have earned your ethical CLE credits for the day. I appreciate you having spent the last hour and 15 minutes with me. I appreciate your thoughtfulness and your approach to representing your kids. I think they're lucky to have you as their lawyers. And go forth and conquer the casino now, I think is what we're supposed to do.